So hi, everybody, and welcome. I'm so happy to have you all with us today. As you may know, there have been some changes to the medical aid in dying legislation here in Quebec recently, and so we are very fortunate to have Maitre Guay with us today to help explain what the changes are and what the impact will be on our community. I'm just going to read her bio to you. Maitre Hélène Guay has been a member of the bar since 1988. She has chosen to develop a practice in the field of health law and essentially focuses her time on representing users of health services and their families. Maitre Guay runs a litigation law firm and represents victims of medical errors or their families, as well as individuals who are the subject of requests relating to their capacity or integrity. She advocates for the respect of people's rights before administrative authorities, such as complaints to the local commissioners, coroner's inquests, professional orders, Human Rights Commission, or the Public Curator of Quebec. She has developed an expertise in representing seniors and defending their rights. So we're thrilled to have you with us, Maitre Guay. I will leave it to you to carry on. Thank you.
Thank you so much for your introduction and for your invitation. I appreciate greatly being there with you, being in contact at distance with you, but really present also, although we are not close. And I believe it's better this afternoon that we are not close because I do, as you can hear it, a bit of an infection. And so therefore, I'm glad that we can conduct this presentation at distance. I see that a few of you are interested in the developments regarding medical assistance in dying, which is a question of care that I'm getting involved into as being a lawyer practicing in health law. So therefore, I will try to articulate as best as possible the different new conditions attached to this new procedure available for certain people. So I'm very happy that maybe you are a member of the society or maybe not. In any case, I'll be also very glad to answer all of your questions when they're raised at the end of the presentation. The presentation you will see here will become available in a PDF format after the presentation, and it will be in the possession of the society. So thank you again for being present, and yet I hope I can manage to change the pages smoothly like this. Presentation framework to start with. I'd like to make, as I do usually, a little bit of a background regarding fundamental rights and end-of-life care. Also the history of medical assistance in dying. I think it's good that we go over it again, although you might be familiar with, but it's always interesting to review what's been done, where we come from, to see where we're going to. Where we're going to in matters of advance requests, which is quite original in the world. We could say, I'll get back to this more in details when we get to point 3. Contemporaneous made request is also important, especially in matters of ALS, I would say, even more so as to advance requests. And in conclusion, you will have the table and you will be able to conduct some discussion. Background, the End of Life Care Act. It was adopted 2014, was June, and it came into force in December 2015. So therefore, there was an 18 months lapse between the adoption and the coming into force. As we recall, it was an act, or it is still an act that is constituted of 4 parts. Palliative care is the first part. Second part is terminal sedation or continued sedation. Third one is medical assistance, medical aid in dying. And fourth one is medical advance directives. With regards to our topic of this afternoon, the advance requests, they came into force October 24. but the bill was presented and accepted in June 2023. So again, very new and yes, material, very much new care and access to care with the component of um, making a demand in advance. Now, how does this insert into our fundamental rights in our society? Well, in the Quebec society, we have a Charter of Human Rights and Freedoms that is very important, as important as it is as is the Canadian Charter of Rights, meaning that these fundamental rights are attached to the person, and the person may claim to have the right to life, meaning how to conduct his or her own life, when life should be sustained, when life should be considered as a personal decision, whether life is life including um, uh, death as much as living. The right to liberty, so meaning one has the authority to decide what's best for herself, himself. Integrity, meaning right to decide what is going to happen to one's body, whether one is accepting uh, uh, tests or blood withdrawals or insertion of catheters. So this has to do with mainly corporal integrity, but it's also psychological integrity, meaning that the right to integrity would mean then to be reserved from attacks that would be in contravention with respecting the integrity, so that the being untouched person, the untouched person's mental or psychological health. And dignity is also been interpreted by the courts more recently in a few cases. I would like to see this with you. And going back to the right to life, the Supreme Court in Carter, you would possibly remember that was the case that went up to the Supreme Court of Canada with Madame Carter, who was living actually with ALS. And what the Supreme Court wrote then, that was 10 years ago, sorry, that it would be the duty to live rather than the right to life would call into question the legality of any consent to the withdrawal or refusal of life-saving or life-sustaining treatment. So we have set in time the notion of the duty to live, which was probably a notion more compliant with our society, say 50 years ago more. Now we're really talking about a right to life, which is recognized in the charters, but was articulated by this judgment of the Supreme Court. And also Carter said, well, you know what, we used to consider life as being something we cannot touch. And now it is clear that the sanctity of life is still very fundamental in our societal values. But Section 7 also encompasses life, liberty, security of the person. And so therefore, what is important is that an individual's choice about the end of life is entitled to respect. So when we talk about integrity, as I was mentioning to you, it's also a very important value in our Quebec law and our society. And the principle is listed in the Code Civil du Québec, so the Civil Code of Quebec. So this important notion is not introduced only at that time. It was introduced way before the adoption of the Civil Code, meaning that the person is inviolable. So meaning that no one can touch the person unless provided a consent, that is also informed. So no one may harm another without free and informed consent. So no one, including no professional, no health professional whatsoever, may decide what is best for the person and may decide that this should be done to the integrity of the person, to the health of the person, to the person herself or himself. without the consent. And personal dignity was interpreted, I think, very interestingly in the case of Ward versus Commission des droits de la personne, so the Human Rights Commission in Quebec. It went all the way up with the case of Ward in 2021, up to the Supreme Court of Canada. And back there, the Supreme Court of Canada gave us a very interesting reading of the notion of dignity. The notion in the charter is written as safeguard of dignity. The safeguard of dignity is not dignity, is safeguarding dignity. And the court goes on to say, dignity person does not protect every person as such, but protects the humanity of every person in its most fundamental values or attributes. And what in this context, and I skip to the last sentence. Dignity is the quality inherent in every human being, the recognition of which, in a sense, defines civilization, and the disregard of dignity defines barbarism. So here is what we think that is very important. Matters of medical assistance in dying and advance request. What we are looking for is respect of the choices, yes, and respect of the dignity of the person, safeguarding her dignity in her decisions, whether we agree, whether we disagree with the decision. And dignity is also inserted in the Charter of Human Rights in Quebec, in the preamble of the Charter. And it's in line with the international documents, as was mentioned in the Supreme Court in Ward. All human beings are equal in worth and dignity, and are entitled to equal protection of the law. So, meaning if one is subject or affected by ALS, he or she is still equal in worth and dignity compared to one who is affected by a cancer or affected by a health condition, mental health condition, and has the right to equality, equal protection of the law. So access to medical assistance in dying is thus so important that it has evolved into our law for the past 10 years. With having in mind these very important concepts that already exist in the law. I thought that it was interesting also with regards to autonomy and freedom or liberty to cite this quote of Madame Justice Lebel, meaning that it is important to respect the autonomy of persons. And what she says here, what she wrote there was that maybe we may disagree with the decision of another person. We could criticize her decision or his decision, but that's his decision, and this means that because that person has a right to decide for herself or himself, we should just act in respect of the decision and give the right to autonomy first, rather than criticizing some decision that is not in accord with our own values. And this is very important because in our law we favor very much capacity to decide. And we favor it so much that we have a presumption of capacity. In the Civil Code, it is stated that everyone is presumed capable. So therefore, meaning that the person who is questioned on her or his capacity, that person doesn't need to prove her own capacity, but it's for the ones who contest her capacity to prove it. Incapacity is the exception. Capacity is the presumption. So therefore, I am presumed to be able to consent to care. Even though I am at the early stage of ALS or advanced stage of ALS, I am presumed to be capable to consent to care. For those who think that I'm incapable to consent to care, this incapacity must be demonstrated by those who contest the capacity of the person. So how is this done? It's done by the way of a medical evaluation to the person who understands, to verify, sorry, for the medical evaluation to verify the person's understanding of the proposed care. And so therefore it's for a professional evaluation to determine whether there is actually incapacity to consent to care. Now, how important is all this here in matters of medical assistance in dying? It is important because the notion of consent to and capacity to consent to care is one major element to determine access to medical assistance in dying or advance requests in medical assistance in dying. So here is what I suggest also before we jump into more details on MAID, the distinction between MAID and the distinction with withdrawal or with cessation of treatment. MAID is a gesture performed by the physician with the intention of causing death, while a cessation of treatment, withdrawal of treatment, discontinuation of treatment is meant to stop the treatment, even if it is vital, say a respiratory support, a ventilator, dialysis. At one point in advanced ALS, there is respiratory assistance that may become necessary. There might be dialysis or means to support ventilation, means to support hydration, feeding that will be considered as vital care. So at the request of the person, the cessation of treatment is not made, but it's rather refusal of treatment or withdrawal of treatment. And the result might also be the death of the person, but it is not the goal itself. It's not the goal of causing, but it's the goal to avoid over-treating, undue treatment. In the case of Nancy B, there was, I believe you have, maybe you have or maybe you have not. The case of Nancy B is self-explanatory for this example between MAID and cessation of treatment. And we will jump into now with on medical assistance in dying with a brief history, whereby I do cite here the case of Nancy B. The case of Nancy B, it involved a young woman of 25 years old who had a neurological disorder and was bedridden. And she had expressed the desire to stop the treatment, which was respiratory support. So she wanted to ensure that she would not go on live for months and years on the respirator. She was very young, so that all the evaluations were done to ensure that she was capable to comprehend her decision. And the judge Dufault wrote, although she wants to be free from being the slave of the machine, and so therefore what will come out of the eventuality of retrieving the machine, then it will be the sickness to follow its natural course. This was in 1992. At that time, we had been living with the criminal code since 1892. And you will see the development went very quickly. In 1993, Supreme Court of Canada, in the case of Sue Rodriguez, decided in 5-4 judges that it was inappropriate to declare sections 241 of the criminal code contrary to the charter. To the contrary, they said it was not contrary to the Canadian Charter. Canadian Charter was adopted in 1982. So Sue Rodriguez, who was also affected by ALS, had brought the case to court and had tried to challenge them. But the Supreme Court was not ready. And the society might then have been sort of quote unquote ready, because there were polling, the Gallup had made a poll, and they had concluded that the majority of Canadians was thinking actually that it was appropriate to give the ultimate decision to the person, although the person was young, and although the outcome would be that death would be provoked by a health professional, they thought it was necessary. And in fact, the doctors were the ones who were supporting very much this these steps towards um, considering that it was necessary to decide to conclude and to make an analysis closer of the section of the criminal code which were still criminalizing the act of assistance in dying. But the majority thought it was a slippery slope and they were very much concerned. So justice, about 10 years, 20 years later, Justice Smith in BC came to the conclusion completely contrary. She said that 241 of the Criminal Code violates Section 7 of the Canadian Charter. Section 7 is the right to life, liberty, autonomy, integrity. And then what happened is that after her judgment, 22, the case went up all the way up to Supreme Court. And the Supreme Court decided 10 years ago that in a unanimous court decision that you probably heard of, that these sections of the criminal code were unconstitutional as they prohibited physicians from granting medical assistance to a person capable of consenting who so requests and who suffers from an irremediable condition causing intolerable and irremediable suffering. So this is the starting point for the Canadian legislation. The starting point for Quebec legislation is June 2014, with coming into force December 2015. The conditions in both laws have been very similar, but at the point a little bit distinct. But I will not go into much details of the distinction. I will prefer to go on to what is of importance for this. And why is this important, even though we'll be talking about advanced request, because these conditions will still have to be encountered with the advanced request. So you need a person of full age and capable to consent to care, so minors are not admissible. Person insured within the Health Insurance Act, so persons from outside the realm of the province with the Health Insurance Act are not covered. Able to make a decision regarding his own health, so that means being capable, right? Suffering from a serious and incurable disease. Well, if we refer to many disease conducting to the request and including ALS, we can say already that ALS certainly qualifies as a serious incurable disease, being affected by an advanced and irreversible decline of his or her capacities. So it's not at the early stage, it's really more down the road that there is deterioration and aggravation and a decline. And that is irreversible because there is no treatment. And experiencing constant unbearable physical or psychological suffering that cannot be alleviated under conditions that he or she deems tolerable. So meaning that the suffering is so intense, it's so persistent, it's so intolerable that nothing can alleviate the pain. So these elements we will see a little bit later. And why there was one crossed line, because it was thought at the beginning that the person should be to be eligible to medical assistance online to be at the end of life. And this was crossed out by the Superior Court decision in 2019 in the case of Truchon in Quebec, was not brought to appeal. So therefore, that's the law in the Canadian country, meaning that one does not have to be at the end of his life to ask for medical assistance in dying. We have evolved, and that you can see how the history is very new, it's very recent. We're living the history actually at this moment, because these changes that were brought by the different bills adopted in June 23 came into force October 24. And these new lines, this enlargement of medical assistance in dying is very important in the sense that it's bringing changes that should be in favor of respecting more of the needs of people who would like to have this type of care. So extending access to incapable persons by means of an advance request, which was asked for many years before. Access for people with severe and incurable neuromotor disabilities. So for sure, people affected with ALS are admissible within this particular terminology. MAID is now being administered by specialized nurse practitioner, so they are considered competent professionals. Also, instead of having the expression handicap, which is used in the federal law, the expression is serious physical impairment causing significant and enduring disabilities. So for those who have this physical impairment, it was not clear before the amendment of 23. So now it's been clear that they are also admissible, pending all the other criteria that they need to fulfill. And the place of administration may be other than the care setting, with the permission of the director. We know also that Quebec has not introduced into his law access for mental health for people who are suffering of a mental health condition or disorder. And for the federal law, we know that the federal government has postponed for another 3 years, starting last year, the introduction of access for people whose only condition is mental trouble or mental illness. So this we'll see in 27 if it comes into force. But now what was decided was based on the fact that there was a need for more in-depth examination of the issue in view of all the many ethical considerations. So when we talk about medical aid in dying, and I'm using here the expression medical aid because this is the expression used by the act in Quebec. And in the federal law, they use medical assistance in dying. And here is why, probably one explanation for that is the definition of medical aid in dying in Quebec is care consisting in the administration by a competent professional of medications or substances to a patient at the patient's request in order to relieve their suffering by hastening death. So the competent professional is the one who will administer the substance that will cause death. So the competent professional is the one aiding in dying. In Quebec, physicians and specialized nurse practitioners are authorized to administer, not only physicians, up until December 7, 2020, it came into force in December. Only then, before, only physicians could administer medical assistance in dying. Now, specialized nurse practitioners are entitled. However, in Quebec, self-administration is not authorized. In the federal law, self-administration, and in the other provinces, self-administration is authorized. So this is why we are probably using the expression medical assistance. So in Quebec, any person whose condition so requires has the right to receive medical assistance in dying. The care may be offered in a facility maintained by the institution, be it CLSC, hospital, CHSLD, in a palliative care hospice or at home, or another location previously authorized by the Director of Professional Services. So you need authorization if you would like to have medical assistance in dying, say in a funeral home. But I've seen I've ran into a situation where My client wanted to go to the chalet, 200 kilometers from home, from a hospital, and hospital wanted expressed the wish to oppose to the transportation, the wish to oppose to the demand, the accompanying, etc. And my client with his mother, um, who was actually he was suffering from ALS, advanced AL in an advanced state. And we finally convinced the institution, hospital, which was long-term care, to let him go, as the place was considered a home. But the authorization to administer outside the location of a care facility has to go through the Director of Professional Services. And the right to receive medical assistance is applied, although it, although the resources are might be raised that they are not sufficient. So it could be, and it has been at times, an opposition from the resources from the institution that we do not have the resources, we do not have the organization. Now we know that the amendments brought to the law a year and a half ago do enforce, do promote that for example, every palliative care hospice has the necessity and provides with the services available for the persons whose condition requires and wants to exercise his or her right to receive medical assistance in dying, that they should provide them with the services. Now, competent professionals, I mentioned a little bit earlier, this is the expression used to refer to physicians and specialized nurse practitioners. Since December 7, 2023, they are entitled to receive the demand and administer. And according to some statistics in 2022, 95% of the competent professionals who had administrators were physicians and 5% were SNPs. So meaning that these numbers and these statistics come from other provinces than Quebec, because back then we didn't, SNPs could not perform MAID. So let's go to advance request for medical aid in dying. What do we mean by advance request? Well, the law is very much detailed, and I can say that not only is it detailed, but it is very a big load to carry once you decide that you want to go through an advance request. Why I say that? You will see in the following slides. We will go through what are the conditions of an advance request for medical aid in dying. Who may first? Well, first, one has to be of full age, 18 and over for sure, and capable of giving consent to care, meaning that one who, for example, would be in advanced stage of ALS with the component of cognitive diminishing sufficiently important of his capacities, then one could conclude that his capacity to consent to care is not present anymore, would not be capable to provide or to complete an advance request. So what it means is that it's probably at the very moment once close to the time when the diagnosis has been issued. Be insured, we saw that earlier, and suffer from a serious and incurable disease. We will look into this closer. When we think about a diagnosis, the issuance of a diagnosis, so it means that not only is a person capable, but the person is also subject to a diagnosis. We saw So serious and incurable disease leading to incapacity to give consent, the third bullet. So the illness must be diagnosed with the component of leading to incapacity to give consent to care. Now it is important to reflect on this because it is certainly clear to us that ALS is a serious and incurable illness. Is it clear for everyone that it is also an illness leading to incapacity to consent to care? I've seen and fought for people with ALS who maintain their capacity to express themselves, to make decisions, to consent and refuse care up until the very end of their life. So, what I mean here is that it might be that it is actually ALS leading to incapacity of giving consent to care. In some statistics reveal that clinically relevant neurocognitive disorders are viewed in 35% of the population with ALS, and frontotemporal dementia is seen in 15% of the clientele. So what it means is that one may not encounter dementia further to the neurologic disease, to ALS. One may not encounter neurocognitive disorders, but may also. So seems to me that it can be qualified as a serious and incurable disease, illness leading to incapacity to consent to care. In any case, it is a neurological disorder that entails consequences and complications that might also permit the person to be admissible to medical assistance in dying and not necessarily with an advance request. The course of the disease will vary from one to the other, and the complications will come. And ultimately, there will be a decision whereby, okay, then if the demand has been made with the person being capable and the deterioration occurs, then one may come to the point that there is an incapacity to consent to care, and therefore the advance request might be effective at one point in time. To talk a little bit closer about the neurological condition of ALS, we can see here in this table, taken out from the annual report on medical assistance in dying in Canada 2023, that it ranks after cancer as one count of medical conditions reported among those who self-reported having a disability. So the neurological condition of ALS is not the sole one, of course. There are many others, but we can see that it is already quite at the top of the medical conditions conducting to a situation of disability leading up to a request for medical assistance in dying. Here, and so therefore, here are the conditions for advance request. Firstly, one needs the assistance of a health professional in signing the form. And the form exists. The form is accessible. You can look it up. You can find it. It's short. It's not very complicated. It leaves lots of room for the person, firstly, to describe in detail her application. In her application, many different elements. Second, the form must be the one prescribed by the minister, or one could make it with a notary. And thirdly, the third condition for this time, registering the anticipated or advanced request with the Register of Advanced Medical Directives. So we will look into this in details because it is quite important to understand how full how are the full knowledge or the full demand that the full steps that must be completed in performing and completing the form, how important it is. The main part has to do with a description, a detailed description of the manifestation. So it's for the person to make a description of the disease-related clinical manifestation. Of course, in ALS, once the person is decided to make an advance request, then the description might be something not so complicated because one has made himself or herself knowledgeable of the clinical manifestation. So writing down the disease-related clinical manifestation, signing to the effect and confirming that the determination of inability to consent to care. So this, once I meet all these clinical manifestations, this will be the expression of my consent to care. So my consent to MAID. Observation of clinical manifestation should be also in the form. Also, the clinical manifestation of illness would constitute the expression of consent on to the administration of medical assistance in dying. So all of these are in subsections in the form need to be filled by the person. And ultimately, all the conditions stipulated by the law must be met before the actual advance request is taken into force, taken into effect. The conditions to the advance request are that all of this should be very much detailed and completed in the form. And in addition to this, the additional conditions are that the person is in a decline, in an irreversible decline, an advanced decline, firstly, and secondly, that the person is also experimenting constant, unbearable physical or psychological suffering that cannot be alleviated under conditions that the person deems tolerable. So we always go back to this expression, and that is the one that is irrebuttable. I mean, it is one condition that it has to be fulfilled. We will see who will fulfill this condition of measuring or evaluating the suffering. So the form does have sort of a few parts. One part is, so therefore, the information for the person regarding the clinical experience. So that person transcribe in her own words the clinical experiences that he would or she would not like to, she would not go through, or that would be a step showing that it is time now to consider that the coming into force of the advance request, because I am not now in a position to consent to care anymore, and I'm in a position that I'm suffering so much that I want to have medical assistance in dying administered. And the information from the person must be also observable at the time of the assessment by the competent professional with a view of administering. So when it comes to time of assessment of coming into force of the advance request, the competent professional shall be able to see these manifestations, okay? Either unable to drink by himself, unable to turn head or see or hear, or something that is clinically observable. Also in the form, there is a medical description of the clinical experiences described. So the doctor will come up also, the doctor or the nurse, specialized nurse will come in and make a medical description. And also the compliance with so therefore there will be also a need to relate the disease and the observable clinical experiences. So meaning that if the clinical manifestation are not coming from the disease, it would be questionable that all of the conditions are met. So it is important that in the form, conditions or the clinical experiences related to the disease are really the ones that can be observed by the competent professional upon the time when it is assessment and it is the time to perform and to proceed with the next step for administration of MAID. Also, the form being prescribed by the minister, um, there is in the form a specific paragraph mentioning that the person shall attest that she has been informed and understands the possible course of his or her illness. So this involves obviously the fact that it was possible for the person to discuss it with her neurologist, with her specialists, um, what is the possible course of the illness. It might be it is probably clearer in matters of ALS than in other matters, in other situations. Health conditions such as a cancer might have different course of treatment, different plan, different outcome, while ALS is probably one that is pretty clear and also with a view of deterioration and decline that is rather rapid. So it's the course is usually known quite early by the person affected. Now the form needs to be dated and signed by the person himself or herself. If incapable to sign, someone else will be authorized to sign for him or her. One may have a trusted party inserted. So this means that the trusted party should also sign the form. If the trusted party is identified in the form, and two witnesses must sign also and must attest that it is an advance request for medical assistance in dying, and the competent professional will be the one signing at last. Now the form must be sent to RAMQ, and one has to make sure that he or she will receive the receipt confirming reception. So the filing is also very important. We will see later for another reason. Now we're talking about the trusted party. Okay, second series of conditions for advance requests for medical aid in dying. A trusted party. We want to define who is a trusted party, what is the role, etc. We want also to define, assessment of the person by two professionals prior to administration of MAID. Okay, what do we mean by that? What sort of assessment, and what has to be foreseen, and what has to be evaluated or what has to be concluded on evaluation. Also, we want to see what do we mean by withdrawal and refusal to receive MAID. Okay, so a trusted party. So the law provides with the possibility, and this was a lot of discussion when we were in a parliamentary commission 2 years ago, and we discussed this aspect of having a trusted third party, which is something that we was discussed that there could be two, and now we're ending up with one, which is the best thing of all. So why a trusted third party? Probably to permit the person to have the authority and the autonomy to decide who could call in the professionals to provoke the advance request for its activation. In other words, so in the form, a patient may designate in the advance request form a trusted third party to whom he or she will entrust some responsibilities. In fact, two main responsibilities. Notify the health or social services professional who provide care to the patient when the trusted third party believes that the patient is exhibiting the clinical manifestation he has written in his form, or that the patient is experiencing, enduring an unbearable physical or psychological suffering. So this trusted third party, this person will call in the professionals, which might not be always there present because the person is at home. The person might be in long-term care, but might not be seen every day closely by the treating team. And so therefore, the third party will who is close to the person with ALS will be one who will be able to observe the clinical manifestations described and will be knowledgeable of the clinical manifestations in the form because he was a party of the signature. He was signing also the form. And maybe also that third party is knowledgeable of the suffering and the level of suffering of the person and the enduring an unbearable physical or psychological and so therefore it is the role of the trusted party is interesting. It is quite a responsibility. It's not an obligation to name someone a trusted party in the form. It is an option because it's a lot of responsibility. I have heard families and clients saying, I'm not going to name anyone there because I don't want them to live with this um, level of responsibility. I feel like I can decide myself and I need not have someone else to handle the demand at the point where it should be activated. And so that is one option. And so I maybe if I don't put in a trusted third party, I will leave it to the health and social services professionals to decide that the clinical manifestations were there and the evaluation of the suffering will be from their point of view. Um, and the evaluation of the incapacity to consent to care might also come from the trusted third party who could say, well, listen, I think that my brother doesn't understand anymore what's going on. I think he is probably incapable to consent to care at this moment. Could you evaluate this? And could we look into activating the advance request? So um, but not naming the trusted party doesn't mean that no one is going to look into this. In fact, health professionals are formed to determine whether the person is capable or not of giving consent to care. So they will be providing with the necessary evaluation of incapacity to consent to care. So, trusted party, an option, not an obligation, and certainly lots of the responsibilities on the shoulder of this person. Now, once we decide that we make an advance request, I mean, for ALS, as I said earlier, it seems to me that the contemporaneous medical assistance in dying, the regular process and not the advance, could possibly be the answer rather than the advance request because of what we see all of these conditions and the uncertainty with regards to the coming into place of the incapacity to consent to care. But in the meanwhile, if there is still a need for completing or a choice to complete the advance request, one needs to remember that the withdrawal is always possible at any time. But it needs to be done by a special form, and it needs to be registered again. Because if it is not registered, then what is going to be available will be what is registered. And so therefore the new form or the changes or the withdrawal will not be taken into consideration because it would not be considered as valid, but it's the one registered that is valid. Also, the question of refusal to receive MAID, this was part also of a lot of discussion we had at Parliamentary Commission, because people tend to think that, okay, maybe not in the case of ALS, maybe in situations involving dementia, there could be situations where the patient who has requested by way of advance request may at the time of administration refuse to receive MAID or resist to care. So professionals are invited to evaluate the situation, note the situation, and not consider that it is impossible, but rather postpone to another time. and enable the person to be in a state that is possible to administer MAID in accordance with the advance request. So the professionals are not to force at any time the refusal of care, but should make a close reading of the expression of refusal. Now, also, what is important is the advance request at the time of administration. The person must be, at the time of administration, still full age, but also incapable of consenting to care. Okay, so consenting to care, the first very important element to proceed with advance request, and the second one, enduring unbearable physical or psychological pain. So how is the incapacity of the person to consent to care measured? As I said earlier, capacity is presumed, capacity must be demonstrated. So it's for the medical assessment to demonstrate if the person understands the illness. So, so how they proceed is they meet with the person and they make an evaluation. Okay, maybe even without a situation of advance requests, professionals and doctors, neurologists, geriatrists, they are all involved into this process of medical assessments of a person's understanding. So it's a five-fold formula to question the person, to question the understanding of the person. Does she understand her illness? Does she understand the proposed care? Does she understand that she has made at one point the demand for medical assistance and dying? That it was her wish, that she has had made these clinical manifestation be the expression of her consent, and therefore not and therefore does she understand that if she does not accept the medication the does not accept to proceed with MAID, well, she will continue on the suffering. She will continue on the severe decline. So it's a matter of for the professional to evaluate all this and see in the balance is comprehension sufficient to conclude that she is still or not capable to consent to care. And they also take into consideration the disease itself. How does this disease affect the capacity of the person to consent to care? In cases of dementia, it's more easily to come to the conclusion that the disease does affect capacity to consent to care. In ALS, probably less, as I was mentioning earlier. So one very important element is also the one of persistent, unbearable physical or psychological suffering, conditions deemed that are conditions deemed tolerable. So how is this measured? This is a big point, and I recall last week with another group how important this evaluation is, this step is, how difficult it will probably be with doctors, although the professionals and nurses, practitioners will probably develop ways to evaluate the persistent, unbearable physical or psychological suffering. Because usually the person who is incapable to consent to care is also incapable to express where it hurts, how it hurts, what is the level of suffering, what discomfort it brings, how persistent it is, how unbearable it is. But elements that need to be remembered here are the fact that it is persistent. So it's not just 1 day out of 3. It's not just a few minutes per day. It's persistent. It's continued. Unbearable means something that you cannot bear it anymore. You cannot suffer about it anymore. It needs to be put an end to, right? Physical is easier to measure than psychological. We make sense to all of us that it's probably that way. And how do you measure suffering that is physical or psychological when the person is unable to express herself verbally or even physically, and non-verbally? So the law has put it into the hands of professionals, like two competent professionals who will have to assess the person um, prior to the administration of medical assistance in dying. They will have to look into the medical situation. Where are we now at this moment? Um, Based on the information that is available to these professionals. So looking at all the information that is also available at that time from the long-term care professionals, from the information given by the family, from the friends, and according to their clinical judgment, they will have to make their own assessment and determine if it is actually uh, complying with this condition. And also the additional element is that this suffering is for the person is intolerable, yes, but it's even with conditions that there are no conditions that can make them more tolerable than what they are. So I think it's that will I step a little bit too fast on this next one, sorry. So I think this covers what we call advance request, and I'd like to make a nice switch now and a next step to medical assistance in dying the camp with the question of contemporary request. Why? Because we also see with the contemporary request that the same expression of unbearable physical and psychological suffering, it's the fourth bullet, is also present. So we have for the past 10 years the evaluation of how doctors evaluate and what is called a psychological and or physical suffering that cannot be relieved under conditions that the patient considers tolerable. So again, the conditions for these requests excuse me, um, be of full age and capable of consenting to care, be insured, and suffer one of the following situations. Either, I'm sorry, I'm just going to cough a little bit. So, one of the following situations, so to be eligible, suffer from a serious or incurable illness. Certainly, ALS fits into this. You have a okay. Or have a serious physical impairment causing significant and enduring disability. So for sure, ALS fits into one of the following situations. And certainly it can come to also getting into step 4, the unbearable physical or psychological suffering. So these are the first 4 conditions for contemporary requests. The procedure is there is also a form, the form that must be signed also in the presence of healthcare and social services professionals with independent witnesses. The form is also maybe also signed by a person who is identified as being in a position to sign for the person herself or himself because incapable to sign physically. The choice has also the choice to make a demand, contemporary demand, is also best to be discussed with her physician repetitively. Most probably, it's probably one thing that is looked into, that it was discussed and it was made further to some discussion with the physician, so that the demand is even more complete. Before administering, the competent professional must also be of the opinion that the conditions are met. So what are the conditions? The consent must be given freely, not with under pressure the family, for example. The person must suffer in a permanent manner, in a persistent manner, and the wish shall be, as I was mentioning a minute ago, must be repeated. A person must have had discussions with members of the care team, discussions also with persons, loved ones to him or her, and also the possibility also to have the discussions with people with whom he or she wishes to talk, a priest, a neighbor, an ex an ex-notary, an ex-friend, the possibility so that discussions are being conducted prior to filling the form. And also the opinion of a second competent professional is necessary also in the form. Now, fourthly, the procedure also, as the law provides, makes it that the competent professional who is having completing the form with the person will be the one to administer the maid. It cannot be delegated to someone else. So it is quite a responsibility for the professional to fill out the form with the person. Usually it takes a couple of hours, if not more, to fill out the form. And that professional should be administering. Now, if the competent professional concludes that the person is not to be administered for a reason, example, that the decline is not severe enough, the suffering is not persistent, for giving you examples, well, then he must inform the person, say, okay, well, we're not yet there. I need to evaluate a little bit more, or we will see in a couple of months where we are. And finally, if the competent professional refuses to administer because of his own values, which is something that is usually known in advance before filling the form, sorry. So this competent professional should inform the director of professional services at the institution, so that this director finds someone else or some other competent professional for the person. I'd like to outline to you what we mean here by the expression of persistent and unbearable physical or psychological suffering under conditions deemed tolerable. So therefore, these statistics come from the Commission of Commission sur les soins de fin de vie. So annual reports are being rendered annually by the president of the Commission sur les soins de fin de vie. And now it's been, as I said, 10 years from the time it came into force. So here we have the reasons why people thought it was necessary for them to proceed with a contemporary demand, making a request for quote unquote regular maid. So 96% of the people who received maid had declared prior that the reason that physical and psychological suffering mentioned in the form. So that was one reason why they would ask for maid. 97% of people link their suffering to loss of ability to perform meaningful activities. 91% link their suffering to loss of ability to perform activities of daily living. So probably we can say that in the clinical manifestations in the advance the request, we will see that sort of mention. At once I'm unable to or not capable anymore to do this and that daily activity, this and that regular, meaningful or regular activity. When I unable to perform this physical activity, then I feel that because it would be too suffering for me. So we will see these in probably in the advanced request forms as elements of description of the clinical manifestation. 73% of the people link their suffering to loss of dignity. More than 53% indicated inadequate control of pain or other symptoms. Makes sense. 47 indicated suffering was related to the perception of being a burden to the family, to the friends, to the caregivers. This is something we are conscious of. 44% suffering was related to a loss of independence, 35% to emotional distress, anxiety, fear, or existential suffering, 32% loss of bodily functions, and 24% report a feeling of isolation or loneliness. And finally, the most frequent reasons for why suffering could not be alleviated in conditions acceptable to the person, because this same criteria, as I said, is in both advanced or contemporaneous requests. 63% thought that the treatments were ineffective. 38% thought that there was no treatment available. 32% refused the treatment, and 80% expressed the fact that the side effects of the treatment were unacceptable to the person. So this is the topic we have had to cover. We've come to an end, and I can certainly say to you that it is still a very sensitive question. Not reasons, but raising ethical and legal issues. There's been legislative responses to the demand to enlarge access to medical assistance in dying. It's not exclusive to ALS. I think ALS does have does qualify as a neurological disorder, and certainly may permit a person affected by this disorder to make a request. And in fact, we had the 2 and 3 main cases in Canada were related with persons who were affected by ALS. So what the legislative response has been is to answer to the necessity to adapt the law for everyone in an equal manner, based also on the importance of personal autonomy and respect of anticipated wishes. So I hope this has enlarged your view of this and has enabled you to become more familiar with the conditions. And I will be more than happy to answer to your questions and comments.
Thank you so much, Maitre Guay. I've noted a few questions, but I'll let the room go first. Does anybody have any questions or comments? Feel free to just unmute your mic or to write it in the chat if that's easier or more comfortable. Mr. Tsopkat, go ahead.
Yes, just a little comment to thanks Maître Guay for your information and your good information and explanations. Thank you very much.
You're welcome, and I hope it is helpful to you. And
yes, for my future. Yeah.
Good. I'm glad to hear that.
Great.
Thank you for that, Mr. Tsopkat. Anybody else? All right, while we're waiting for people to get their questions together, something that's always worried me about the advanced request for medical aid in dying is, and I think you talked about it a lot, but I'm just going to ask the question anyway. Is it, I worry about, someone else making the determination that the person is suffering a lot, or making a decision early on about when a person would be suffering enough to make use of medical aid in dying. And then when that person finds themselves in that position, even if they're incapable of consenting or not, that they're actually okay somehow in that. I'm not sure if it's clear what I'm saying. Like, for example, there's a family member that has dementia and wouldn't have wanted to get to this point in the dementia, but there was a time where if he'd had control, he would not have consented to go this far, but the person seemed to be okay. So, like, you know what I'm trying to say?
Yes, and you're given a very right example that it is something uh, very sensitive, um, and we may even question how is it possible to foresee all of the situation? How is it possible to uh, trying to make it to foresee to put it down in writing? These are going to be the clinical manifestation that I would like you take into consideration as my step towards consenting to MAID. So, but the family will not be able and should not be able to say, now, although it's written in the form, uh, doesn't seem to be suffering. Okay, well, if this is the case that he doesn't seem to be suffering, well, maybe the clinical manifestation will not show us, will also be on the same line. And maybe the professionals will also be on the same line that we cannot conclude that there is so much suffering. So it's not going to be possible to proceed or to administer. Now, we have to remember that at the time of preparation of the advance request, it should be very seriously taken into consideration by the professionals that they have to make a discussion with the patient completing the advance request. They don't leave it to the patient. Patient has to complete it with the professional with discussion, and the professional has to verify whether what is written in the form is really something in link with the disease itself that is conducting to incapacity. That it's not only, okay, well, I mean, say for example, ALS. It doesn't cause, if we take ALS, um, it does cause incapacity to talk at one point. Okay. But I think for the hearing, it's not the one that is going to be affected as much as talking. So if the person says, I'm going to be suffering so much, and this is unbearable to me that I cannot hear the sound of the music, I cannot hear the sound of the trees, of the birds. Uh, and if there's no link between the disease, the complications of the disease, and this clinical manifestation, it should be reviewed at the time when they prepare the form. It should be discussed then. It should be coherent then, so that at the time of administration or activation of the demand, there's so much questioning. And how can we see this clinical manifestation here? It was never written. It cannot be linked. So there's a lot of work to be done there. Puis also, as I said, I mean, it's the time when the professionals are called in to proceed with the advance request. They have to take into consideration all information, not only the medical information, but also the family's point of view. So they take into the what is written in the form, so the importance of the form, take into view also the knowledge on the disease itself. what is reported by the family, what is reported by the treating team or by the health professionals who are following the person. And yet they make their own clinical judgment on is there unbearable suffering now. And again, I repeat, it's a difficult task. And we tend to rely on them, but they have a heavy responsibility.
Thank you.
Difficult.
It's reassuring. I think what comes to mind too for our community is, you know, early on in the diagnosis, when we speak to people, often they'll say, I wouldn't like to, you know, once I get to this point, you know, my quality of life will be shot and I'm not interested. And sometimes that assessment is stable, but much more often what happens is when you see what can be done to palliate, then they push the yardstick further, right? So I would just be concerned that if they have to set a yardstick in advance, that once they get there, they end up being okay with but can't communicate it somehow, that I would just be afraid of us making a mistake. I mean, but I'm glad to the way you describe it, that, you know, when the healthcare professionals have to take everything into account, and that not only the form would prevail if you could have other elements that show the person is not, for example, suffering and
Yes.
in an intolerable way.
Yes, yes.
Thank you. We also have Dale in the chat, who said, thank you so much for your clear and concise explanation. Are there any other questions, comments? No? Okay, well, I'd like to thank Maître Guay once again for very thorough and important discussion. So thank you. We're very fortunate that we've had Maître Guay do many conferences for us over the years, and it's always a pleasure to have you. I'll also remind everyone that's here that if there's anything that comes up after the fact and you have questions, you can always write to us, contact your counselor. This is a difficult subject matter and it might raise some feelings afterwards as well. So if you want to chat, please don't be shy. We're here. And I wish thank you all for being here today.